Hey guys, Mike Fronteri here, back with another retirement theory video. So today I'm going to be talking about a question I get all the time. Client will call me up and say, hey, I visited with my attorney and he or she suggests I should set up a trust. Do I need that? Or another thing, I'll be meeting with a client and I'll ask them whether they've had their will updated recently. And very often the answer is either no or I don't have a will. Is that bad? So before I answer that, a quick caveat. You should always seek the advice of legal counsel in any and all legal matters. All right, now, maybe you've spoken with an attorney recently, or maybe you haven't, and you just want to know some of the basics of why you might want a will, or perhaps do you need to go a step further and set up a trust. And by the way, when I say trust in this context, what I'm really talking about is a revocable trust, or sometimes it's called a living trust, okay? This is different than one might set up in order to, say, hide assets to qualify for Medicaid. All right, so before we get into a trust versus a will, let's take a minute to examine what happens when you don't have either one. All right, so for those of us who pass away without having drafted a will of our own, there's good news. The state has already drafted one for you. So when you die without a will, it is said that you die intestate. And what happens is, so when this happens, your estate will be distributed in whatever fashion that your state has determined by law. So you might take a few moments, if you don't have a will, to look up your state intestacy laws and see what might happen in that case. You might find out that your intentions do not necessarily match those that the state has for you. So, assuming you would like additional control over the distribution of your assets, then in virtually all cases, a will is a good idea. And as you probably already know, a will is just a document that spells out who gets what when you die. And when that time comes, your local probate court will appoint a representative for the estate, which is known as an executor or an executrix. And with a will, of course, you can name who you'd like to serve in that role. So basically, probate, as you also probably know, is simply the process of proving who gets what within the will. Probate isn't always, but it can be a pain, and it can be expensive too, especially if you have more complicated assets like a business or things that are not the easiest to value, like artwork or expensive jewelry or real estate. And when heirs cannot agree on those values or who gets what, and the will isn't crystal clear, the process can get extremely cumbersome. And once you throw in court fees, executor fees, and attorney's fees, it can also become extremely expensive too. Needless to say, the whole thing can get pretty hairy. So often then, when you visit an elder law attorney, they may recommend that you set up a trust. Again, we're talking about a living or revocable trust. So what can a trust do that a will can't? Well, let's first figure out what it is. And really, I think the best way to think about a trust is to picture it like an empty box, where you get to set the rules for anything that goes inside that box. Those rules dictate not only happens to the assets in the box after death, but also in the case where you become medically incapacitated. Right? And this is already, by the way, one major difference between a trust and a will, in that it can provide for direction in cases other than death. Okay. Now, with a trust, you have someone called a trustee, whose job it is to carry out the rules that you have put on that box. And in the case of a revocable trust, you typically start out as the trustee. And you're also able to change the rules for that box while you're living, which is why it's often referred to as a revocable or living trust. Now, once you pass away, however, those rules can no longer be changed. So one of the things that people like most about a trust like this is that, unlike a will, the terms of a living trust do not need to go through the probate process. So not only can this save time and legal fees down the road, but it's private. Say, a will that goes through probate is a public document. So having a trust set up can afford you and your family some additional privacy. Also, keep in mind, if you have property in more than one state, your estate would need to be probated in each one of those states. But if all of those properties instead were transferred into that box, that trust, you could skip all of that. Another advantage to setting up a trust is the additional control that you have over the distribution of your assets. So maybe you want to hold off on, having your 22-year-old son receive all of your assets at once. And you'd like to time out the distributions to him, so over maybe a number of years, okay? Or maybe you could direct the trustee to dole out certain amounts of money, either based on attaining a certain age, or perhaps even achieving certain goals that are important for you. So maybe graduating from college or getting a job. Now remember, a trust can provide you with a lot of control, and that's great. But keep in mind that the trust only dictates what happens to the stuff inside that trust box. So if it's not in the box, the trust doesn't control it. So you'd need to be careful not just to put existing assets in the name of the trust, but also future assets that you obtain need to be named to this trust. This is often one of the reasons that a trust is often drafted in conjunction with a will, right? So the will can actually act as a sort of catch-all for things that didn't get placed in the trust before. Okay, so they call this a pour-over will, as it basically pours over any non-trust assets into the trust at death. So it seems like a trust is a more powerful estate planning document than a will, and in most cases it is. But is it necessary for your situation? Well, if your primary concern is avoiding probate, there are actually a lot of things that you can do without either a trust or a will. Just the titling of many of your accounts and real estate can avoid probate on its own. And any joint account, for example, that provides for rights of a survivor, simply pass to the other surviving joint tenant at death. Keep in mind, this would not avoid probate in the case where both joint account holders pass away at the same time. However, this too might be avoided by adding what is called a transfer on death registration to that account or property. That transfer on death registration basically allows for beneficiaries to be added to that asset. All right, so let me hedge that a little bit. There are a number of states that actually do not allow for this kind of registration on real property. So you'd have to check your own state rules on that. But like for bank accounts, investment, or brokerage accounts, you should be able to use that transfer on death, or sometimes called payable on death registration, to name beneficiaries on these accounts. This can be a great way to move assets out of your probated estate. You might want to ask your bank if they can add a transfer on death or a payable on death registration to your accounts. And speaking of beneficiaries, a huge part of most people's assets are their retirement accounts, right? And assuming you have beneficiaries set up on those accounts, those too will pass outside of your probate estate and go directly to whoever you have named as beneficiary. Same for life insurance policies. So, you can see that in a lot of these cases, once you take out real estate, retirement accounts, your investment accounts, bank accounts, a lot of times there's not a heck of a lot left that would either go through a will or a trust. And if you don't have the desire to have that, that future control of the disbursement of assets after you're gone, it can make the case for setting up a trust somewhat less attractive. Keep in mind some of the downsides of setting up a living trust. One of the primary ones of those is just the cost to set it up. They typically cost a lot more than setting up a will. Not only that, they can be a bit of a pain to get assets into that trust. You might have to change the deeds on real estate, retitle your investment accounts, and again, you need to remember that anything new that you acquire during life would also have to be titled to the trust. So, by the way, you need to be exceedingly careful with retirement accounts if you list your trust as a beneficiary. Depending on how they're drafted, a trust can actually cause adverse tax consequences on those retirement accounts to your heirs. In any event, a revocable trust carries with it a number of pros and cons, and it's important that you weigh those out before having one drafted for you. One final thought. Whatever you do, be sure to communicate your intentions clearly with your family or whoever it is that you're going to leave assets to. Most conflicts arise when one beneficiary expects one thing and another expects something different. Sometimes the legal document that you've put in place solves that confusion, but sometimes it doesn't. So not only can the ensuing time and expense be wasteful, but the emotional toll that it can put on a family is often the worst part. So, do you have questions for me? Let me know. Come visit me at www.retirementtheory.com or send me an email at mikefrontera@retirementtheory.com. Did you click subscribe on this video or follow me on Facebook? I think that you should. You'll continue to see videos like these on everything retirement planning. Once again, thank you for joining me. Take care of yourself, and we'll see you next time.